I think we have all the board members here. I think we have a lot of helpful staff members here. I think we should begin, if that's okay. My name is Carol Lear. I'm the chair of the Law and Licensing Committee. This is the Law and Licensing Committee of the Utah State Board of Education, meeting on September 9th, 2022. Welcome to everyone. I see the members of the committee. We have 3 members with us today. Can we start by introducing ourselves, Mr. Hymas?
Yes, thank you. I'm Matt Hymas. I represent District 3, and I'm just happy to be here. Thank you.
And Cindy?
Hi, Cindy Davis, representing District 9. Good morning.
Thank you. And Member Klein?
Hi, I am Board Member Natalie Klein. I'm over District 11. Good morning.
Thank you. Thanks so much. And thanks again as we start to the staff who's so well prepared and so helpful. So with that, I have the first item on the agenda being a discussion of a data sharing agreement with the Division of DCFS, or not the Division of, but Division of Child and Family Services, and our Data Privacy Officer, David Slay. I'm thinking David's going to start this out.
I believe actually Tanya Albornoz is going to start, and then David will supplement or add.
Great. Tanya.
Yes, good morning, Chair. I'm here. I'm Tanya Albornoz, Coordinator for Prevention and Student Services, and for some reason my camera is not working. So I apologize for that. I just wanted to provide some context on this request. This request came to us from DCFS as a result of they have times when caseworkers need to go out to schools to interview children, and it's very time sensitive. These matters, sometimes they have to respond within an hour to the allegations of abuse or neglect and do an investigation in an interview with the child at a school. And what happens sometimes is that they have on record, or they're given information about a school that the child is attending, and they go to that school, and that school is not the correct school, or else they don't have any information, so they go off the address of where the child is residing and that school within that area, and it ends up not being the school that the child is attending. So they spend some of their time trying to track down the child so that they can fulfill their obligation under the law to interview the child. And so they approached us with the request to be able to access data through the data information gateway so that they can more easily track down where a child is attending school in a more time sensitive matter so that they can fulfill their obligation. And just to make committee members aware, this is information that they already have access to. It's just simplifying the process so that they can track down the child. So the request is that the information be shared with their intake staff, which is where the calls for abuse and neglect come into. So it's not providing the information to every single caseworker throughout DCFS, but just the intake caseworkers that take the calls, so that they can then add that information to the allegation before they send it out to the CPS investigator. And so that is the request, that they be able to access that information. And I'm going to turn it over to David Saleh so he can speak to the data privacy issues.
Right. And before you get started, if it's okay, we were not able to get a DCFS representative with us. They're having
That's correct.
a turnover in staff, and they had some other really urgent matters in their office that they needed all hands on deck. So unfortunately, we don't have a DCFS person with us, but I think David can maybe be helpful along those lines. So go ahead, David.
Sure. Thank you, Board Member Lear, Chair Lear. I just, Tanya explained that really well. I just wanted to add that both federal and state privacy law do include provisions specifically for this sort of thing for authorized caseworkers to be able to get access to this sort of information. What we're talking about that I think I can add is that we'd be giving them access to the student search functionality within our data gateway. And if you look in the data sharing agreement the attachment that's part of it, it includes the data set that they'll be able to see with that, which is essentially, again, as Tanya said, information they likely already have some of to begin with. So it's mostly for matching purposes. It's the student's name, their birth date, but ultimately, so it's so they can get confirmation of the student's school of enrollment. And I also like how Tanya pointed out how timely is essentially what we're trying to get at here is they're going to get this information, but in some cases they need it within hours. So this is the quickest way we could think of to be able to help them get that information.
So just to clarify, I have a couple of hands up. I'd like to go to them in just one second, but I just want to clarify, this is a child safety, a child protection effort. Is that accurate?
That's correct, Chair.
And again, to repeat something else, DCFS has access to this information per the law. This just facilitates that so that the child might be protected more efficiently in a more timely way. Am I hearing that correctly?
Yes, that's also correct.
Okay. If there's nothing else that you want to start out with, I've got two hands raised. Are we ready to go to that question or discussion? Are you okay about that?
Yes,
Okay. First one is Member Klein. Go ahead, Natalie.
Thank you. I have several questions actually in looking at this. First off, in the background section that we were given, it talks about those caseworkers that are responsible to investigate cases of educational neglect or similar issues. In reading about educational neglect, that doesn't sound like something that would be an endangerment to the child. And the other thought is if they're at school, if the social worker is actually looking for them at school, they're probably safe from whatever endangerment they may be facing. I assume this means there's some kind of endangerment from people at home, and that's why DCFS has been contacted in the first place. So, I mean, you answered a couple questions because my husband's a social worker and deals with DCSF. And they, when somebody reports the issue, that's usually where they collect all the information. So it sounds like sometimes they don't get accurate information from that. But I worry about giving them access to the data gateway, because then they have access to a whole lot more than what's listed here. And going to the data gateway and seeing what all is available there for them to access. And you've got school climate surveys, you've got Cactus, and you seemed like huge amounts of sensitive personal data on kids where it appears that if they wanted, they could go mining for more information on the student, how they've answered certain quizzes and questions related to their home life and such. And I don't know that our statutes give them that access to that kind of information, but there's all kinds of sensitive information on the data gateway that if we give them access, they will be able to see a whole lot more. And I just don't want to put our kids in a situation or families in the situation where all of this information is being dug through to find more cause from to take a child away from their family, when we all know that the surveys are not 100% accurate, that oftentimes kids don't even read the questions, they just click on numbers, and there's a good chance that they've answered something about themselves that just isn't so, and could be used to actually take them away from their families. And so big concerns there. And like I said, if they're at school, there's time to do a few extra phone calls to locate the student. I am not for giving access to our data gateway to DCFS.
Okay, thank you. That was what I was going to ask you at the end. You're saying you don't want to do this at all. Is that what you're saying?
That is correct. They have
Okay.
other ways and means to do it that they've always done. They can continue that way as far as I'm concerned.
Thank
I
you.
don't think it's worth the risk.
Okay, thank you. Tanya, I think could we go to Member Davis first and then you could respond to both? Is that okay? Okay, Member Davis.
Do you know how many intake, how large is the intake staff? How many people?
Chair, may I respond?
Tanya,
Yes, may I respond?
please, yes.
Thanks. That's a great question, Board Member Davis. I do not know how large the intake staff are. We could reach out to DCFS and get that information if you would like that.
Looks like David has his hand raised. Maybe he
I
has
don't have
additional.
that.
Oh, something else. Okay. Go ahead, Cindy.
Follow up, Chair. Do we have the ability or do we ever do this? Do we ever audit or monitor once we open up these contracts to see or have records shown that the access to the gateway was limited to the intake referrals? Is there a way to monitor that or see who's accessing the gateway, or would that be an opposite privacy problem, because then we would know who is being referred through DCFS?
Now, that's an interesting question. Tanya, do you have the answer to that?
I think, David, do you happen to know
David,
the answer to
May?
that question?
Yeah, I did want to speak to some of the points Board Member Klein made on the security within the data gateway. I'm not sure to Board Member Davis's question exactly what is logged and what we could track. But what I am aware of within the data gateway is, first of all, that all access within it is role-based. So they would be assigned an account that had limited access. So a lot of the stuff that was suggested that they might be able to access, only what you see in this attachment B that's currently on the screen, that is the only information that would be within their assigned role they'd be able to see. And this is how it works actually for anyone who accesses the data gateway. There's a variety of possible roles. So, I mean, a simple example would be a district assessment director is going to need to be able to see very different data than a school level administrator.
So just so I'm clear, I want to make sure I'm understanding. So those bulleted items under number 4 are the only things that could be accessed anyway.
That is correct.
So
yes,
most of that are, half of it is under FERPA is student directory information anyway.
correct.
Right?
Yeah.
Okay, that is interesting to know.
Can I do one last quick follow-up, Chair?
Yes, please, go ahead.
I would just say that makes a big difference for me, that's a limited access, and I really appreciate you pointing that out. And the other thing is, we have a lot of school choice in our state, and we support that, and it's a beautiful thing for families and children. But it makes, you used to be able to look up the address and go to the school and interview the child, and they are doing a lot of work. As a principal, I never knew who they were interviewing. I'd come back from a classroom visit and my secretary would say, DCFS is in your office. And I'd be like, okay, I'd go back out to another classroom visit. I didn't know, it's very private, and they respect the privacy of the child and the families. And so I do know they are doing a lot of work, and with this limited access, I think I can support this request.
Thank you.
Especially since we have so many charters and different kids going to schools in different places other than that are attached to the address.
That's a good point. I want to go back to David and Tanya to respond to Member Klein before we forget her questions. So Matt, I see your hand is raised, but let me go to Tanya first and then David, unless you prefer different.
No, that's great. Thanks, Chair Lear. Thanks to David for pointing out that those are the data items under number 4, the only data items that they'll be able to access. I just wanted to respond to Board Member Klein's question about whether it's just educational neglect that they're going to be investigating, and that is not accurate. As far as my understanding is, it's all the different allegations that come up, and sometimes again they have to go interview the child at school if there is a risk of harm that's presented to the child. If the child returns home, that's why they would be trying to track the child down at school. So it's not just educational neglect, but all of the different allegation categories that DCFS would be investigating.
Thanks, Tanya. David, did you have anything to add to that or something to add?
Yeah, just I wanted to add that because I was the one who wrote the educational neglect bit and others, I think is the way I worded it. And I think it's just to show that our legislature has already deliberated on a lot of when DCFS should be involved. And I included educational neglect because I think in my mind, that's kind of the lowest level, just to show that our legislature has already determined that this is, they want DCFS to be able to get involved fairly quickly, even if a student is, just has large amounts of absenteeism. At that point, the legislature has already decided that DCFS could get involved. So I included that as kind of the lowest level where it would start, but as Tanya explained, it could be for a variety of more concerning offenses as well.
Thank you for adding that. And Member Hymas has questions or his hand up. Go ahead, Matt.
I do. Thank you. I have a couple here, and hopefully they're just quick answers. First off, the list here, can you just tell me briefly why would the DCSF need the SSID or the LEA student ID? Is that
David or Tanya? Go ahead and just respond to his questions, either one of you.
I'm not sure exactly why they would need it, other than that it's built into that role already. We would need to build a new role to have it be more limited, to remove that, because we're giving them the basic student search functionality and nothing more, and that's already included in it. Certainly in the future, we could look into creating a completely different role that wouldn't involve that. But the reason that's in there is because those are the most basic identifiers because this is typically used by schools to look up a student, and that's always a one-to-one. A student has a unique student ID, but they might not have a unique name. If there's multiple John Smiths, they might find.
David, would it be accurate to say that SSID might be helpful to separate the many John Smiths, the many Taylor Sorensens that might exist? Is that part of it?
Yeah, that's the rationale. The SSID is intended to be SS is statewide student identifier. So it's intended to be something that is unique, that even if they transfer to different schools, they'd be able to match on. So I could see some benefit in, if it is something that is over time an issue and the student has transferred to multiple schools, that the SSID would be the same regardless of which school they were attending. And that could be a way that they could identify that over a period of time that there might have been issues depending on their investigation.
Okay, thank you, David. Matt, go ahead.
Yeah, thank you. So okay, does DCFS, do they have access to this all the time, or is it only as requested?
The way it would be set up is that we would be providing logins to these intake workers, and they would be able to on demand log in, see the information. If the account falls into disuse, I think it's a year. Someone from our IT could correct me, but if over a year passes where they do not log in, then we automatically lock the account. And we've also talked a little with DCFS because we do know that there is some turnover with this role on their side. that we'd want to keep that list as up to date so that when someone is no longer working with them, that we can remove their access so they can't be looking it up if there's no professional reason to do so.
So
Thanks. Go ahead,
Sure.
Matt.
Chair, just one more, just let me share some concerns that I have if I can. Here we're giving access to child information. And we're not talking about just the things we see on the screen here. With the IDs, we can look up, as somebody mentioned earlier, attendance records. We can look up grades. This allows employees of the DCFS, those who are employed and probably a little bit of time afterwards. Let's say a disgruntled employee says, you know, I'm out of here, I'm taking, and this is an extreme example, right? But the access is still there at any given time to any given employee. We don't know, we can't protect that data. What I'm worried about is, let's say that the DCFS is just looking through the data and says this student has been gone for so long. I am inserting my will into this family, and I'm going to fix something that has not been reported, or, you know, we're almost taken away from the school. We're trying to do two different things here. From what I'm hearing, I'm just not there yet. I'm not comfortable yet saying, yeah, we're gonna open up the school systems. As an educator, I'm not comfortable with that. As a parent, I'm not comfortable with that. And I haven't heard anything here today that would bring me any comfort. It doesn't look like we're providing securities to families. It almost looks like now we're saying, you better be careful because the DCFS is watching. That's what I'm feeling at this time. And I usually don't feel like that. I'm not a big brother type of guy, but this is what I'm feeling. Can you help me with that?
David?
So to the point of, again, that a student ID number is all that is needed to be able to look up all sorts of other information. I'm not aware that is the case. In fact, like schools can, board member Lear mentioned directory information, which is information that a school can essentially make public about any student, provided that parents are given the option to opt out of those disclosures. And schools are allowed to use student ID numbers as directory information, provided that they are not the only credential needed to get access to the kind of information you're talking about. So within the data gateway, they wouldn't be able to look up the attendance or scores or any of that. And I don't think that with a student ID alone, that they could log into, say, the school student information system and start looking that up. Because again, that requires at least one other credential. They would need to know a password in order to do that. So hopefully that kind of gets to that a little bit, about that concern of, if we give them this, they'll be able to get all sorts of other information. But also, with that said, you know, I think one option could be, if we feel like this isn't completely ready, to go back with DCFS, figure out the exact information that they do need, and see if we could, again, tailor a specific role within the data gateway that only gave them that. So if they, and again, that's why it'd be nice if they could have been here today, but, you know, they could say, oh, no, we don't think we'd need the student ID at all. And then we could maybe look at creating something more tailored and specific, especially if it would make all of you more comfortable with moving forward with something like this.
Thank you.
One more follow-up.
Matt, do you have any more follow-ups, Matt?
One more, I promise. I do wish DCFS were here, and I'm sure that they would say, look, we're not going to do that. And I believe that as an organization, they would not want to do that. But let me just give you a quick example, and then I will rest my case, if that's the proper term here. If I go to my school's Compass login and it says students enter your student number, and I have access to that number, and then I could just enter a password, or say I forgot my password, and I could reset that, and I could be in, right? That's how easy it would be for me to gain access to a child's information, and at the same time, a parent's information, right? A lot of it. So yeah, I think there's a little more work to do on this, a little more securities. For me, I'm not convinced yet. I just think it's too easy. And with that, I'll I'll put my hand down. Thank you, Chair Lear.
Thank you. I just wanted to clarify one thing, and then I've got to go to, then I want to go to Member Klein and Member Davis, but clarify for me again. I'm hearing two different things, I think. You're saying, I thought I heard you say that that list on the left, it's on our left to look at, is all that DCFS workers would have access to through this login. Matt seems to be saying he believes that if anyone can log in and get information on a student, that access cannot be limited. Which is true, David? Do you know?
I mean, at least within the data gateway, this was all it would be. If we're looking at a different system, so Board Member Hymas mentioned Compass. And again, where it's like there would be the SSID plus a password. I'd have to look and see, I'm not familiar with Compass, whether that alone would be enough to reset a password. I would say if that is the case, then that sounds like a major security flaw on Compass's side. Because typically any of those password reset requests would end up going to a different email address, one that was already tied to the student, which presumably, again, this individual would not have access to. But also, as I said, I'm not familiar with Compass enough to be able to say if that is the case. But if it is, then I would say that is a major security flaw on the side of Compass, that you should not be able to, with just this information, be able to start resetting passwords. You would need a lot more information, I would think, to be able to do that.
And I think I'm saying something a little different. Just one second, Matt. I think I'm just saying, I think I may be asking something different. You're saying, David, that if a DCFS worker logs in, he can only see that list on the left. He can't, in fact, dig deeper, see the student's grades, see the students. He can only get the information that's on the left. Is that right?
That is correct. Within the data gateway, they would only have that. So the question I heard from Board Member Hymas was whether they could take that information and use it to log into a different system. And again, that's hard to say depending on the system, but I think most of them, they would not allow for that, because this is information that would be fairly common to be able to find out. Certainly within the school community, any student would be able to know this information about any other student with relative ease. And that's why I think a lot of times that I wouldn't be as concerned, but again, since I'm not familiar with Compass or every possible system, I can't say that with certainty, but just that if that were the case, then that system would have a major security flaw. But it wouldn't be the data gateway's fault, it would be the system.
Right, and you've answered both of the questions both of us had, so thank you for that. Matt, are your hand's still up? Still?
Yeah, I think it's a fair point that David's saying here. The point is that I'm making is yes, we have these bulleted lists, and it's limited on the side, but there's things that we can do with information on that list. That's the point that I'm making here. Thank you.
And we don't know whether that's exactly true or not. Natalie.
So I'm just wondering, again, in the description that we were given, they talk about having to make multiple phone calls and wasting precious time to do that. What about having maybe a DCSF liaison of sorts at the USBE, that if they have a question, they're trying to locate a student, they can call that number, and whoever's on the other end that has authority and access to this information can give them just what they need in order to actually locate the student without having to give DCFF access to our system. I think it would be just one phone call, one-stop shop, they can get what they need and go find the child without putting the student's data and personal information and family's information at risk.
Well,
I'll get the location.
I think that's a reasonable question, and I want to go to Tanya or David, whoever, but I wanted to point out that we have 160 LEAs. So if we had even a fraction of those, a person, a child at risk in a fraction of those a day, that could be 30 or 40 phone calls. But let me go to David or Tanya and see if you have another response about the feasibility of that.
I don't think that we necessarily considered that option. I just think we would have to think through what that means in regards to staff capacity and who would have that responsibility. So I think that's definitely something that we can discuss internally. I just don't, I think that this was the way that we felt would be the best way to do this right now. So.
Thank you, Natalie. Go ahead.
Is there any, do we have any kind of indication on what the numbers are currently? How many times DCSF is trying to find a student on any given day, like the averages?
Do we know that? That's something a DCFS representative could probably more easily answer, but do either of you know?
I don't know that, Chair,
David.
but I can make a suggestion. Since DCFS was not able to be here today, what we could do is put this to next month's agenda and see if they might be able to come and answer some of those questions.
Thank you. That's an idea I also had. Cindy, let's hear the rest of the questions, and then we'll have the questions that we can transmit to whoever that person is. Cindy?
Yeah, I'm reticent to commit our staff's time to do that organization's work if we don't have it codified with an FTE fiscal note allocation assigned to pay for someone to do that. And if we could get that, I'd be fine with that option, actually, if it was manageable with, given time constraints and numbers, which I'm unfamiliar with. But the way I understand it is that in this current request, the intake officer could see the date of enrollment in the school and the exit date of the school, but could not have access through our system to attendance records to scroll through and try to find educational neglect or anything like that. So I'm trying to work with the information that we have access to here. The only thing that gives me like serious heartburn is the social security number. So,
and I don't see that. I don't see that listed.
Is the
SSID
ID?
I think that's the student's ID number assigned by the school, is it not, David? Or am I misspeaking?
Yeah, the state board nor any schools collect student social security numbers. It's actually in our state privacy law that we are not allowed to collect those. The SSID is the statewide student identifier, which USBE generates and is intended to be an ID number that follows the student throughout their academic career, all the way through university. So it's actually a commonly shared number that.
Okay, and that's different from the LEA student ID. There's two different student IDs.
Correct. LEAs assign their own ID numbers. This is typically the one the student already knows. They might use it to access their school lunch funds, for example. So yes, every student typically has two school ID numbers, one that's generated by the state and one that is generated locally.
And the social security number is not anywhere in this. Oh, I feel much better about that. Okay, thank you.
Thanks, Cindy. Cindy, you have other questions?
No, but I'm happy to wait until next month to have, to ask more questions of DCFS, if that's kind of the will of the group. I'm happy to do that also.
Thank you. And I think without objection by any of the committee members present, I think that might be a better way to handle this, to just ask to delay this for a month and then have a DCFS representative here so we can know we can pose some of these questions to the DCFS person. That person can come with information so we can know for a fact, Matt, if someone can, as someone who's an employee of a different agency could, and I almost feel silly saying this as a even a not a tech or a student privacy expert, but we know there's a lot of ways, and lots of probably students could be more savvy about mining information than any of these people. So what I'm asking for DCFS to reply is if it would be unreasonably accessible or readily accessible or inappropriately accessible, as opposed to could they if they're a bad guy. Cindy, did you have something to add to?
I just, if we're going to wait for them to come and answer questions, could they come or someone contact them and have them come prepared to answer questions like the number of intake calls that member Klein had asked, things like this, so they don't come and say, oh, well, I'll have to go back and check my records and get back to you.
Helpful.
Put it off another month. And quite honestly, there are some serious abuse situations going on out there, and kids are getting hurt. I've seen it too many times. So I want to be a good partner in this, but I want to be wise and careful and make sure the data is secure and all of that. So
thank you. I agree 100%. And the other thing I'd like to add is we have LEAs right now under siege by county attorneys and some child protection groups and advocates saying they are not reporting at the level they need to report. And if there's a breakdown in terms of reporting and getting the information readily to people who can make a difference, that is dangerous for children, and it's also puts our employees at risk. So I also would like to address this, not push it down, not kick the can down the road too far. Tanya, you have a response, and then Matt.
Yes, thank you, Chair. I just wanted to say I'd be happy to reach out to them if board members can provide a list of questions. I'd be happy to forward those questions to DCFS so that they can come prepared next month.
Thank you. And if we're sincere in these requests, please do this in the next 10 days and not let it sit there till the day before the board meeting. Then that person can be helpful. Mr. Hymas.
Thank you. And I apologize for painting myself into a corner where I said I was done with questions. I just want to make sure, and Tanya, David, maybe either one of you know this, or maybe this is a question for the DCFS that can be preloaded for them. Is there any scenario where the DCFS could use this data to initiate its own report, or are we still reporting to the DCFS?
Tanya?
I do not know the answer to that question, Chair, but I'd be happy to relay that to DCFS so they can answer.
Thank you.
That'd be great. Is that okay, Matt?
Yep, thank you.
Thank you. And so I think without objection, we're going to put this off till next month when we can have somebody from DCFS here to speak for that agency that is our partner, that does protect children on our behalf, works with us to do that. I don't want to underestimate or understate the importance of that in this discussion. Privacy is important, but child protection, I would say, is more important. So we will, again, without problems, do that. We just have one final item before we leave this, and I hope I don't misstate that, but I want you to speak up, Angie. We are unfortunately losing David Saleh, our fabulous student privacy officer, to a really exciting opportunity for him. So he will be leaving at the end of the month. Is that right, David? And he's not replaceable. So that will be unfortunate for the USBE, but the opportunity for David is great. Can you tell us just briefly the new job you're taking? I thought it was a great big honor. So
thank you.
Up.
Yeah, I'm going to be the Director of Youth and Education Privacy at the Future Privacy Forum in Washington, D.C.
And so he'll be moving to DC eventually and becoming one of those bureaucrats at a bigger level.
Maybe. I mean, it's a nonprofit that
Oh,
brings
cool.
industry and policymakers and a variety of groups together to work.
Oh, wow.
Privacy
So
problems.
we
And
may be able to see you again in a different role.
hopefully, yeah. And for the time being, I'm going to be working remotely with the possibility of eventually relocating, but no immediate plans to do so.
Thank you, David, and thank you for everything you've brought to the USBE and your expertise over the years. I said to Angie, and who may want to speak more, just for another minute about David and how great he's been. Angie?
Yeah, thank you. So David's been at USBE for 7 years. Before he was with Student Data Privacy, he actually worked in our assessment, on our assessment team, working as a data specialist for the assessment team. So we've had him on our team for 7 years, and just he and Whitney were kind of the inaugural team members for the state of Utah and Student Data Privacy. So he and Whitney have done a lot of wonderful work over the last 5 years, which is a tribute not only to the two of them, but to the state of Utah and representing USBE and Utah on a national stage. So we're excited for David. Any of you who've been watching the Student Data Privacy team's work over the last 5 years may have recognized him as the lead actor in a lot of the training videos. And so anyway, just wanted to share in board member Lear's kind of like bittersweet goodbye to you, David. And just I've personally loved working with David. We'll miss him, but we're also so grateful that he's taking that expertise to national level and helping others with the good best practices and policies and laws that are going to protect our students. So thanks, board member Lear, for giving us this time to just wish him well. And
of course. And I thought I had a Cindy, did you have something else? Did I miss you? Okay. Thank you again. Thanks to all the team, and we look forward to answers next month and a DCFS person on the hot seat instead of both of you. So
Thanks,
thank you
David. Good
again.
luck.
Congratulations.
Thank you.
Yeah,
thank you very much.
exactly. Thank you so much. We're moving on to our next item without objection, which would be item 1.3. R277925, effective teachers in high poverty schools. We'll have that discussion. Angie, are you starting that out?
Yes, I am. Thank you. Angie Stallings, Deputy Superintendent of Policy. I should have introduced myself before I spoke a moment ago. But this rule is being updated. It's a very small update related to legislation from last session, HB 315, which added kindergarten teachers as now eligible to receive stipends for the effective educators in high poverty schools incentive program. So previously to this last session, the incentive was only available for teachers in grades who are teaching in grades 1 through 8. And now we'll be adding kindergarten teachers per the legislation. Erica Horsley is the specialist who is here in the room with us, and she is able to answer any questions that the committee might have. But this is the only amendment in the whole rule, is right there, just adding kindergarten to the rule. And so Erica and I are both available to answer any questions.
Thanks, Angie. I do not see any hands. I don't have any questions. Would someone like to make a motion? Mr. Hymas.
I'll make a motion. Or
Please.
I will move that the committee approves R277-925 draft 1 on first reading and forward to the board for approval on second and final reading.
The motion is that the committee approves R277-925 draft 1 on first reading and forward to the board for approval on second and final reading. Any further discussion to this? Erica, I didn't want to cut you out of this discussion, but I think it's pretty self-apparent. So unless there's additional staff info or our committee questions, that's the motion. Please vote, committee members. And I see 1, 2, 3, 4 yes votes. Thank you. And moving then on, that was super efficient. Maybe it's just relative. Item 1.4, we have a discussion again of R277911, secondary career and technical education. And you know, I did not even ask Kathy if we had any public comment, and if we did, it might be on this item. So Kathy, did we have any public comment?
We did not have anyone contact for comment.
Perfect. Okay. Then I would ask that, I guess, the primary person on this, Jeff Van Holten or Talia Longhurst, whichever one is wants to speak first.
I will give a quick intro and then pass the torch to my good friend and colleague, Talia Longhurst. Jeff Van Holten, Policy Advisor for the State Board. Glad to be here today. Happy Friday. And Board Member Hymas, I just want to give you a shout out. I really appreciate the background. It looks good. Like to see the reverse from staff. I didn't realize those existed, so that's really fun to see. We have got, oh, go ahead.
Oh, no, I was just going to say thank you. I thought we were all doing this, but apparently I'm the only one here. Come on, board members.
You can if you want to. You don't have to.
Well, glad to be here today regardless. R277911, this one is the CTE rule. You'll see in the agenda, this is a repeal and reenact. So just as a reminder, what we're doing here is we were taking the old rule, and because there were so many planned edits to it, we decided it would be easier for all of you to read and for us to handle if we just deleted the existing rule and rewrote it in new format. So that's why it looks really long, because you've got the old rule all struck out at the beginning. And I'm making you all motion sick now. So please feel free to close your eyes. We start around the low 400s with the new rule. So I just want to point out most of what we're doing here is reorganizing and reformatting. There's not, this isn't a complete departure from what the last rule had. And we have had some comments since the last committee hearing, and I did want to highlight that we did take those comments into consideration, and you will see those reflected throughout. One of the primary comments that were received last month, you'll recall, was some concerns around the high school WPU bucket of money that CTE has, and wanting to make sure that the required completer course numbers and concentrator numbers that an LEA would need to have to receive a certain level of WPU add-on funding for that particular bucket. We amended those down to match some of the commentary that we had to make those a little more accessible. As you recall, the goal was to get LEAs to stretch a little. We've been operating at the status quo for, I believe, over a decade. Talia will have to correct me if I'm wrong there. And so it was time to take CTE to the next level, which we love to do. And so we kind of reached a compromise on that particular piece, and you'll see that reflected here. We also received some comments regarding some of the protected classes that were called out for non-discrimination. You'll see we have changed that to state discrimination that is prohibited by law, so that all of the types of discrimination that would be prohibited by law are called out, wrapped up into that as well. Also a convenient way to not have to change the rule anytime federal law changes regarding protected classes. So an easy way to keep that clean. But with that, I'm going to pass it over to Talia, and she can dive deeper into some of the specifics around what has changed and answer any questions that you may have regarding this rule. So take it away, Talia.
Thank you.
Good morning, committee members. My name is Talia Longhurst. I'm the State Director of Career and Technical Education. With me on the in the meeting today is Wendy Morton. She is one of our CT coordinators. And for all of the answers to questions that I don't know, Wendy will pop in and help to answer some of those. I just wanted to begin by pointing out that this particular board rule really is focused around state CT add-on dollars. So this really is a rule focused around career and technical education add-on funds, how those are distributed, how programs are operated through the state. And as Jeff mentioned, the goal is really to stretch again. It's been almost 15 years since we really updated some of the requirements in this rule. And our goal is to stretch again and to have LEAs really work on connecting what we're doing in the classroom to the board strategic plan, to portrait of a graduate, and to look at depth of instruction. And that's what we're trying to encourage, because we know through various data that we look at regularly, that those kinds of things, that depth of instruction is a significantly important component of a student's what keeps students in school. And we know through the data that that actually is happening. And so we want to continue to encourage that. I am happy to take your questions. I think Jeff did a good explanation of some of them, of the bigger things that you're seeing as changes in the rule, but I'm happy to take questions.
Thank you. I'm not seeing any, or now is the time for questions, and I take that back. I'm seeing every hand raised. Let's start this time with Member Davis.
Yeah, thank you. I just forwarded a couple of questions. One, we had asked last time if we could find a way to mitigate some of the cost losses for those handful of charter schools that we had talked about last meeting. I just wondered if we did that and what the plan was there. And then I have 3 questions or concerns that have been brought up by Washington School District Business Administrator, and want to just see if you could address those as well. I just forwarded them to you so you'd have them in writing to make it a little easier. And that may be also why the other board members have their hands up as well, but I'm wondering if we could address these. But let's first tackle the one with the mitigating the losses for the charter schools, if possible.
Go ahead, Leah.
Thank you, Chair. I believe that we took some time over the last couple of months to meet with all CT directors, a representative group of CT directors, folks representing charter schools, to really talk about what is achievable, as Jeff mentioned, and they have voiced support for the requirements as currently seen in draft 3.
Okay, thank you. And then the
1 second, I want to make sure, Cindy, you see the way it was changed. Is that right?
Yeah, I'm assuming you made some formula changes that helped.
Okay.
With that situation, give time for them to not have significant loss.
Thanks so much. That's highlighted on the screen. All right, thanks, Cindy.
And then should I do the next 3 one at a time, or do you want me to just kind of go through all 3? And then Chair, what would be best?
I think if it's okay, since Talia has them now, right? Did you receive them from Member Davis? Then I think she could just address them one at a time, if that's okay with you, Member Davis.
Okay, sure. So the first is maintenance of effort is a federal mandate required for Carl Perkins Fund. Under the changes, the district would still be required to follow this federal mandate, even if they choose not to accept Carl Perkins funds. Is this correct?
I am going to tag in Wendy Morton. We'll let Wendy answer this first question.
And then maybe let us know what the requirements are and why we moved to that, why we moved there if we did.
Thank you. Go ahead, Wendy.
Good morning, Wendy Morton. I'm a CT coordinator at USBE, and I work with LEAs on the formulas for our CT add-on and the funding allocations. The question about maintenance of effort is that the answer regarding that question is that we have had maintenance of effort requirements in place for CT add-on dollars for, I think, since add-on started. I would have to go back that far, but since the add-on was awarded from the legislature, there have been maintenance of effort requirements tied to that. Those are state dollars and not federal dollars. Because it is an add-on and the intent of those funds is to use, sorry if my internet connection is spotty, it's telling me I might fall off here. The intent of those funds is to be used as added costs for CTE programs, that the regular WPU is to maintain all courses. And so in our board rule, we have some language that requires LEAs, and it is this rule, and it has been in this rule, that talks about the maintenance of effort. That dollar amount is tied to only when LEAs generate the regular WPU, and it's not tied to how they receive or do not receive Perkins dollars. So yes, it's true, because it's tied to state dollars, it's not tied to how they generate federal dollars. However, those dollars, then we can, as a state, can use those, how they spend their regular WPU and CTE programs does qualify. As a state, we report maintenance of effort. Each LEA does not report federal maintenance of effort. But as a state, we report our state maintenance of effort, which is a little more complicated than just how an LEA spends money. It has some ties into post-secondary as well. And so that federal maintenance of effort is a larger number that encompasses a couple different points, including the allocation for ADM, or sorry, including the allocation for added CTE funds. And so they kind of mix, but they're not set, they're not contingent on each other, maybe is the best way to describe that.
Can I follow up?
That, yes, go ahead, Cindy. I'm not sure you quite answered my question, but I'll let Cindy go ahead first.
So what I'm hearing from you is that we've had MOE for a long time. It's not new to this rule. And we've had MOE with state funds, not necessarily federal funds. What I'm hearing from the LEA is that the MOE would require the same requirement as the federal funds. And what I'm hearing from you is that the MOE would require what we've always required from state MOE and not adding anything additional, and does not meet all the federal requirements. Is that correct? And have we changed anything with the formulas for MOE from the past in this rule? And if so, what are they?
What you stated is correct. And we have not changed anything from around maintenance of effort from what we have been doing in the past.
So it's the same status quo.
It is the same.
Next question is limiting CTE carryover to 30%. Most of the money used for CTE is MOE money, which is general district funds set aside for CTE use. Adding further restrictions on when general WPU money must be spent is not general oversight of education, it's micromanagement. But I want to go back to a text that I've gotten from two board members that talks about specific expenditures. And it says that, for example, the cost of electronic and trade equipment is unlike other areas in education. It's necessary to have substantial reserves in order, for example, to buy a new hydronic car lift or dental medical equipment. The IT needs are a whole other ballgame. So this is a concern to the LEAs. Can you help address this? Why we went to the 30% and what's the thinking there?
Go ahead, Julie.
Well, I'll begin and then Wendy can jump in and finish up the pieces that I missed. But the idea is that there have been instances, and it's significant instances, or else we wouldn't have tackled this issue of seeing large carry forward amounts. It's not every LEA, it's not every year, but there have been significantly high carry forward amounts. And so the idea, the thought here is that there are times, you are right, when it is important for an LEA to carry forward some funds with equipment needs, opening new schools. Those things are all important and reasonable. But when we see consistently high carry forward amounts from year to year to year that are not being spent down, that is a concern. These are add-on funds, and the idea is to use them for the purpose which they are intended, which is to pay for those high-cost items. And if LEAs are not using them in the way that they were intended, we want to talk with them about that. Why are they holding on to funds? If they have a plan, then they would be allowed to continue that and move forward. If they don't have a plan, we want to talk to them about how to properly and allowably use those funds as allocated.
Follow-up, Chair.
Yes.
So what I'm hearing you say is there's a provision in the rule if they are saving for a hydronic car lift, or they are saving for a big IT or dental equipment, there's a provision in the rule that they could create a plan that would allow them for whatever years they need to during their plan to get that amount of money to carry that forward. And beyond that, you're putting a limit on the carry forward because money's, from what I hear, being stockpiled, I guess, that would be in excess of maybe what some of those costs would be. And so this is an effort for LEAs to spend the money in the add-on. And the add-on is specific to CTE, correct? Not general WPU funds? Or is the add-on general WPU funds?
I think you're
That
muted.
is accurate. Everything that you've summarized is accurate. It's only C. I apologize. Can you hear me now?
Yes.
I apologize. It is respective only to CT add-on funds, and exactly what you summarized is correct. That if they are below the 30% in carry forward funds in any given year, they would not need to talk to us at all about that. If they're higher, we talk to them about what their plan is, what they're saving money for, and if it's reasonable, we approve it and everybody moves forward.
Okay, so I think the plan makes a big difference, but I also just, in fairness, I said to the board members who brought the concern, you know, we've put this off for 2 months, so there may be a conversation in full board if we pass this through today. If the LEAs really feel that 30% is just totally unreasonable, that they need to bring evidence forward and tell us what is reasonable. And they haven't responded to that nature yet. And so that may be a conversation when they have time to think through and respond, that comes forward in full board. And then the last question or concern is reducing the indirect cost rate for CTE add-on funds from the unrestricted rate to the restricted rate keeps CTE programs from paying their fair share of costs. Many CTE classrooms are larger than other general classrooms, requiring more custodial cleaning time, heating and cooling, maintenance, etc. Add-on dollars are meant to offset the higher costs of CTE classes. Please do not ignore the additional general costs. So can you talk to us about why we're reducing the indirect cost rate for CTE add-on funds from unrestricted to restricted, and talk to us about the rationale and what's happening there in this rule?
I'm sorry, Carol. I'm going to let Wendy speak to indirect cost rate. She is our expert in that area, and I would just confuse you. So,
thanks. Go ahead, Wendy.
So to answer the question around indirect cost rate, there's been a request from some LEAs to reduce that number back to the restricted rate. That's one of the reasons. One of the other reasons is that over the years, this rate has been communicated to some LEAs as restricted by our predecessors, myself and Talia, that the intent of these funds was to be restricted. It is an above the line as award from the legislature as part of the MSP program. And so originally it was communicated as restricted. There's been some LEAs requesting that it go back to that because it is a limited amount of funds, and we do allow a significant amount of direct costs to be charged. So your example of equipment, high cost equipment in carry forward discussion, costs around having even some IT staff and purchasing the electronic equipment, it has all been direct charges to the program by LEAs. And so there's a significant amount of direct costs that get charged to the program, in addition to right now, an allocation, in some LEAs, a large amount of unrestricted indirect costs. So our process in this was to allow for the direct costs that they need, as well as allowing some indirect costs to help support the LEA, but not and in some cases, and our financial operations department would be able to give you a good example of where everybody sits, but some LEAs charge 19% in unrestricted rates, and then a restricted rate is more around 10% or 8% of the pool of funds. So it can be pretty significant difference that then eliminates the ability to purchase those pieces of equipment that are so costly to make the program function well. And so that's really been the discussion.
Yeah, so I can see if we're using, 20% for indirect costs, that could be problematic for kids. But I don't know what the fair amount is, for utilities and such. 20% seems high. But I also think that if the legislature didn't codify or if they put it above the line, it puts us in a bad spot, quite frankly. Because there is that flexibility and that potential to use 20% of costs that should be going for, equipment and instruction for kids to go to heating bills for the school. I don't know how to resolve that issue. I'm gonna have to chew on that, and maybe some of my other board members have some thoughts, or staff has some thoughts. I don't know what to do about that one, if anything.
Angie, can you speak to that? And then I'll go to Member Klein for quick. Cindy, was that your last question?
And
yes. Okay, go ahead, Angie.
Thank you. And I wish I'm trying to channel Deputy Superintendent Scott Jones right now, but something that I wanted to share that I believe is the case, and I will check and confirm with either Deputy Jones or Assistant Superintendent Jacobson after this. But if we, the state board or the legislature, don't provide for that differentiated rate ability, meaning the restricted versus the unrestricted, the LEA is forced to charge that higher rate for CTE, that higher rate. So meaning the LEA doesn't have the ability to say, even though our general ICP is 19%, for CTE, we're just going to do 5% or 10%. They have to charge the same rate for all of the programs, that unless there's an exception in either from the legislature or the state board to charge that lower rate. So I wanted to let you know that discretion is not available for LEAs. And so that's why you'll see, and we've seen this in a couple of other rules as well, where the lower rate is indicated in a rule or for a program for that reason. And I just wanted to provide that additional information, and I'm hoping that I represented our financial ops experts appropriately.
Follow up, Chair.
Yes, go ahead.
So we put the provision in the rule to give LEA more flexibility, because in the current status quo, they're forced to charge the 19%?
No, not quite. It's not that we're giving them more flexibility. It's that if we feel that, for example, CTE dollars that we don't want 19% to be charged, but instead 12 or 10% to be charged, we would have to designate that in the program, because the LEAs don't have the ability to charge less. Once they have an unrestricted rate of, again, I'm just using 19% because I think I heard that amount from Wendy. They have to uniformly charge that rate amount across all programs. It's not that they can say, well, we'd really like to, not charge the higher rate for these select programs because we want those dollars to go to support, special ed or CTE or whatever the program is. That's all I was trying to say. So it's not that it gives them more flexibility. It's just that there's really just two rates. And if they're not allowed to do the lower rate, they have to do the higher rate.
Last quick follow-up, Chair, on this one question. I may come back with more because this is a pretty convoluted, not convoluted for my brain, because I've read it a few times and now I'm still trying to wrap my head around it. But so then, to your point, Deputy Superintendent Stallings, but to this business administrator's point in Washington District, what it does essentially is, if they determine that the indirect cost rate across every program is going to be 15%, then they're saying by reducing and specifying for CTE, then they actually are not paying their fair share of the 15% across the LEA rate, because then they're only paying 9% or whatever it is that we have. What do we specify in this? I can't remember. What's specified in the rule, the percent?
Is it at a percent, Wendy, or is it just the restricted versus unrestricted?
It's restricted versus unrestricted, and each LEA has their own amount that's negotiated annually.
Okay.
Okay, well, put that into layman terms for us, and maybe my other board members understand this fully, and I am the one who's trying to wrap my head around it. But so you're saying that what we've put in this rule just ties them to whatever they have determined for themselves?
Yes.
Can I try?
Oh, they can't charge more for CTE than they charge for their other programs?
That's I think the problem. Can I try?
Okay.
Try this for a minute. That the point I'm understanding is what you just said is accurate. That if an LEA has determined a 15% indirect cost for all administrative fees for all programs, that's all they can charge for CTE. And where it becomes a problem is CTE is a more expensive program because of larger classrooms, maybe takes more to heat them. The HVAC is more expensive, and yet so CTE can't bear its fair share because it's a more expensive version for the most part of all curricular programs. Is that true? Am I saying that right, Talia or Wendy?
I'm going to jump in if that's okay.
Yes.
So yes, so what you described is what they're saying. I would say that in an LEA, the CTE is being charged direct costs to set up extra ventilation, direct charges to set up extra equipment, and aside from custodial costs, aside from electricity, all of those other pieces that make a CTE classroom unique are being direct charged to the program currently. Each LEA submits all of their information to our office to negotiate with our office, not myself, but financial operations, to determine what their LEA restricted rate and their LEA unrestricted rate will be each year. So they go through a process of submitting expenditures to our office, and we have someone in our office that works with them to negotiate what that rate is. When an LEA sets that rate, they are then, as Angie described, required to charge that rate to any program that falls within the unrestricted rate that is determined either, as Angie described, by board rule or statute, or restricted rate. And so once that rate is set, they're required to equally charge those costs around to all programs that fall into those categories.
Is that codified?
So that I cannot answer.
It's in, we have a board rule. It's federal. So the federal, and I apologize, board member Lear, I just jumped in.
Oh, go ahead, Angie.
Yeah, so there's federal regulations that state that if you're going to charge ICP, you have to do it across not just those programs that are funded through federal funds, but state funds. We also have a board rule, and I can find the rule that describes what Wendy was just stating, where each LEA negotiates those two rates. They kind of work on it internally, and then also work with our staff to make sure that that's, and I wish we had Deputy Jones or another staff member. I could text to see if one of our staff could come and join us, but it is in federal state code. And then we also have a board rule about how we negotiate or how LEAs set those rates.
So that number 3 is the law. So we don't have flexibility there anyway. So we don't even need to continue the conversation as far as I'm concerned. I don't think we need Scott if that's the law.
The only flexibility I think we do have, and Wendy, please correct me if I'm wrong, is the board does have the authority to say that an LEA can charge the either the higher unrestricted rate or the lower restricted rate. And so you have in other rules, this isn't the only program, designated certain programs where you say, for this program, we want you to charge the restricted rate, not unrestricted. So Beverly Taylor Sorensen is one I'm familiar with. I'm trying to think others, but there's not a lot, but there are programs where we have said for this program, you only charge the restricted rate versus unrestricted. So that is a policy call. The board does have the authority, but the two rates are established by the LEA in consultation with USBE staff.
But it seems that the problem here then is that this rule anticipates telling LEAs to charge the lower rate, and that's the objection from the BA. Is that right?
I think so. And then, of course, you're going to have CTE directors who would have the opposite. I mean, that's always the kind of the difference of one who's running a program would say, yes, keep it at the restricted rate because then we have more funds to pay for the programs for students. And those who are BAs who are looking at a district or charters, full budget, they're always going to have different opinions. But the point is, if you don't state that they charge the lower restricted rate in this rule, the LEA has to do the higher rate. So that's the decision that the board has to make in this rule.
So I have a specific follow-up, Chair Lear, but I can wait till after Member Klein goes if hers are specific to this piece.
And I want to go back to maintenance of effort. But Natalie's been really patient. So let's go to Natalie, and then Cindy, we can come back to you, and then I can get my MOE question later too. Go ahead. Member Klein.
Okay, so I'm still trying to wrap my head around it as well on the whole funding side of things. But I think, I don't know if I'm looking at the same draft as what you have up on the screen, but on the draft 2 from the August 4th meeting, on line 458 and 459, there's an addition to this new version where it says, provides all students with a seamless education system from public education to post-secondary education driven by a plan for college and career readiness as defined in section, and this is the part that was added, as defined in section R277462. And so I looked up that rule, which incorporates by reference for its definition, the third edition college and career readiness school counseling program model framework that we have. And so I'm now looking at that framework. And on page 35 of that framework, I just want to read you this paragraph about funding as it relates to both CTE and the college and career readiness school counseling program. And I'm trying to understand how the two are interconnected better. I'm not sure if I understand, but I'll just read you this short paragraph. Under LEA and administrative support, it says, it is important to recognize that the Utah College and Career Readiness Counseling Program is adopted at the LEA level. Available incentive funds flowed to the LEA for distribution by the local career and technical education, or CTE director, or school counseling director from the funds received through CTE add-on funding. Also, as a reminder, the funds available from Utah College and Career Readiness School Counseling Program were never intended to be the sole source of funding for school counselors. Likewise, CTE is not to be the sole source of funding for a program designed to serve all students. LEAs and local schools generally provide additional funding to support professional school counseling at about 5 times the amount received through Utah College and Career Readiness School Counseling Program. And then it goes on, but I'm just, if you can help me understand what I just read and how it relates to the discussion.
Talia, would you be the best person?
I can start, and let's see if I can answer your question. So many, many years ago, prior to my time at the office, and I've been here going on 18 years now, so much longer than that, the legislature took some school counseling funds and block granted it with CTE add-on funds. Those are specific funds that are given to USBE for specifically school counseling programs. Again, it's just block granted. School counseling actually lives in a different section than career and technical education for oversight and function within USBE, but those funds, and it's relatively minimal amount of funds. It's certainly not designed to fully support school counseling, but those funds were block granted. And so by statute, we allocate by formula those school counseling funds intermixed within the CT add-on pot of money, if you will. And I think what that document is trying to say, what you read, if I understand it correctly, understand what you read, is that CT funds are not to be used to support school counseling programs aside from that specific allocation within the CT add-on amount.
And it says available incentive funds flow to the LEA for distribution by the local career and tech director. Career and technical education director. What are those incentive funds?
I don't know that I would use the term incentive. That's not a term that I would necessarily associate with those funds. Those are just funds designed to help support a school counseling program. And there are requirements that they have in order to qualify for those funds and to continue to receive those funds.
Okay. So before I turn it back to you, if I just can make one comment based on that addition to the rule, where it says as defined in section R277462, that then references this the College and Career Readiness School Counseling Program model. It's what, how many pages long is this? It's a really long document, like 100 pages probably. It incorporates this entire document by reference into this new rule. And I have so many concerns about this document. It is absolutely full of social justice drivel and these incorporating these attitudes, mindsets, and values into our students as a requirement for CTE and this school counseling program, which are intertwined throughout this document. So I cannot support this new rewrite because I don't support the document that it references. And yet, you know, the part that was in there before, a plan for college and career readiness, is still there. It's just this attaching it to this document is hugely problematic. And I can send you a copy of this document and all the highlights of what I have found to be incredibly concerning.
Thank you, Natalie. And can I just ask a few questions to maybe simplify the questions or the whole that whole issue and make sure I'm looking at it correctly? First of all, I'm wondering if your only point in referencing R277462 was to give a more technical, it's not just any plan for career and college readiness, but rather it's a specific plan. Is that
very specific? Yeah.
Is that the point? And Talia, is that the point in referencing the connection between the two?
Correct. So we reference the plan for college and career readiness, and as that plan changes in Board Rule 462, we didn't want to have to reopen this rule to realign every time. So it's referencing the board rule, and as the board makes changes to that particular board rule, then we continue to remain in alignment without having to revisit this rule.
And then another sort of, again, simplifying question. The point is that CTE pays some money to the general pot for career and college counseling because those counselors also counsel students about CTE pathways and courses. Is that right? That is accurate. Okay, I just wanted to get at the purpose for that payment. I don't necessarily understand all the choices about formulas, but I think that's the purpose of giving some money, paying some money out of the CTE pot to the school counseling pot that generally goes to LEAs. Natalie, did you have other questions, or was that?
I just had one more. Last month we had a couple of pretty hard-hitting public comments regarding this rule, and they were asked to send in their comments so that they could be addressed and looked over by our legal counsel. Just wondering if anybody had the chance to review that and give feedback on those public comments.
Talia, I don't know if I thought one of them was, or maybe I'll go to Cindy. I thought one of them had to do with how to fund kind of a fair funding for a consortium of charter schools. That was one of them, but maybe I'm misremembering. Cindy, did you have a different recollection or other?
There were two. There were three big pots of feedback. There was the charter school consortium, which I think we've addressed in the draft.
Right.
There was the aligning the language of the discriminated classes to the CTE rule, but that rule didn't have the word religion in it, which really frustrated people. And I think sent an inaccurate message to the public that somehow you could discriminate for religion, which you can't. So in the new draft, I think they've just taken out all those and just said, follow the law, which includes religion. So that was the second pot. And then there was a woman who came and gave it's a ton of feedback. And I asked her.
That's the one I'm referring to, Lynn Taylor and Lisa Burns.
And I asked our AAGs to review that because I wanted to know if the feedback presented legalities that prohibited us or caused legal problems with our rule, or if it was more a series of opinions and it from what our AAGs told me was that it did not present legality problems with our rule. There is an overarching opinion that because this ties to this and this ties to this and this ties to this, that CTE is bad. So notwithstanding those ties, then we have to ask ourselves as board members, then do we throw out CTE? And here's the bottom line. Do our parents want us to throw out CTE because of those ties federally, or those programs, or those opinions that these are bad ideologies behind this? And here's the thing. If we do that, we lose 236 electives that our parents and students are choosing right now. And so this is really difficult. And I'll just give you a few of them. We lose, these are our highest enrolled courses. Food and nutrition, always our highest enrolled course. Then we lose that. Business office specialist, one of the next. Exploring computer science, child development, Woods 1, commercial photo, interior design. And so then it's really tricky. Like I don't think that my constituents want me to get rid of it's actually 297 CTE elective courses. I don't think my parents want to lose those for their students. And so that's where I have landed on the email. And that's why I asked for, but I would have had the email created legal problems with our rule, then I think that would have to make us take serious issue. I think board member Klein may have some comments about that same feedback, but I tried to do my due diligence to really figure out what is being said here in the email. What are the connections? What are the potential negatives? And are those coming out where the rubber meets the road? And because of those negatives, will I tell the families in my neighborhood that they cannot take interior design? And I'm not going to do that. So that's where I've landed on it. But I think Natalie has some thoughts. But I still have my other question on the funding, Chair, after we've addressed this portion.
And I won't forget that. I just, in the interest of time and not belaboring too narrow of issues, although this is a policy question, I just had a comment from Angie that yes, Ashley Beal, one of our AAGs, said that Member Davis encompassed her opinion and her review of the email that we requested, and that Cindy said it very accurately and very completely, and that was and so Ashley doesn't feel the need to speak, if that's okay with you, Natalie.
That's fine.
Okay, so did you have other questions, Natalie?
Sorry, I thought you were calling on Ashley.
Oh, no, Ashley.
Okay.
She feels like Cindy represented what her opinion was. So
okay. Well, I just from the feedback that I've gotten from the field, it sounds like the infiltration of the ideologies is not necessarily coming into the actual classes yet, or to a very small degree if it is. But it is filled all of the policy side of things, as is evident by this plan for college, Utah's plan for college and career readiness school counseling framework that I've referenced and can send you, and that's a USBE document. So even without all the ties to this organization or that, or the federal type of things, we are on course for moving in that direction, and it would be really wonderful if we could sever those ties and save our CTE program so that it doesn't become corrupted, so that we can save those classes for kids to choose on their own and not be coerced by school counselors that are becoming more salespeople to fill certain college and career pipelines to kind of socially engineer our future workforce. And that's where it's going. So.
Okay, thank you for that. But help me understand a phrase you used. Infiltration of what ideology?
So if you, like I said, if I send you the actual document that's referenced or incorporated.
Don't need to send it to me. I can go to the link. But
Okay.
what do you mean by infiltration of what ideology?
So it's basically your ESG, it's your environmental social governance mindsets, which are the same, pretty much the same as our social emotional learning competencies. They are feeding the ESG, the social emotional learning scores, the attitudes, values, and beliefs, dispositions that they need for a 21st century learner or good global citizen needs, all match up with the same things that ESG is requiring of corporate America, so that the corporate America is demanding these kind of attitudes and values in the people that they hire. So they are changing how we do CTE in order so that, I mean, it's the new definition of college and career ready. It's not the technical skills side, it's the soft skills side of attitudes, values, beliefs, and dispositions.
So you don't believe in social justice, is that what you're saying?
Not when it is used to contrive and control individuals' outcomes, instead of letting them have free choice in where they go and what they do with their lives, instead of putting them into these Marxist type career pathways.
What's a Marxist type career pathways? Can you give me?
It's the Russian model of doing things where they plan their economy, they plan their workforce, where the gaps are, what they need to fill, and they then put students in that pathway to fill the needs of the workforce. So it becomes a career training or a workforce training program, instead of truly allowing that freedom for students to choose their own path and not be coerced or persuaded. I mean, they're very careful the way they do it, so the student feels like they have a choice, but they're really being directed in certain ways based on their competencies and whatnot. So I just don't want it to go in that direction, but that's where we're heading, so that it remains a free market idea of, you know, students choose where they go, and we're so concerned about and what they do with their lives, but we're so concerned about filling gaps and closing all the loopholes so that every child gets a college education. And there's, you know, that we are taking out or starting to eliminate options for students to have a different idea of what to do with their life.
All right, thank you. And I didn't mean to take so long, but
I hope that helps explain.
Well, it seems like our CTE options are expanding, so we're not limiting them. And I guess I don't share the belief that all school counselors are indoctrinating students. But
well, again, the idea is we're moving away from those technical skills. We're offering more classes in it, but the idea is to infiltrate those classes with the soft skills of social emotional learning, so that they have the right. So to be college and career ready means now, according to the documents I've been reading, which are many technical documents, it's about graduating with the right mindsets, attitudes, values, beliefs, dispositions for the future workforce.
Collaboration and maybe the ability to communicate, those kinds of.
Right. I mean, they sound good. That's why it's easy to sell. But when you read through and you realize what they really mean, when you watch, for instance, Castle's training videos, it's about coming to believe that our country is systemically racist.
Okay.
Coming to believe that certain people have privilege where others don't, and
going way beyond our CTE rules. So thank you for just clarifying for me what you meant.
Oh, yeah, that's kind of where I'm coming from. Thanks for indulging me and asking.
Did you have another question? You took your hand down. I guess you don't. No.
No, I I just think, especially in 328, we have asked our teachers to avoid certain things that could go with, like, for example, a transformational SEL. But
it's in all of our own USBE documents.
But those skills like communication and collaboration and creativity, those
are good. Yes.
Great. Those are skills that our students should be participating in their courses. But I think the bigger issue is being really careful not to say that students have to choose an academic path, that parents and students should not be allowed to choose a trade path and to take some of these courses that lead to a trade path. We currently have 38% of our students across the state who are not choosing either. They're not choosing any post-secondary training, not academically, college, not in a career, nothing. And so I think the goal here is not necessarily to create tracks like Russia, but to provide choices for children and families so that children can eventually have a family sustaining job, skills and understandings academically, and some of the soft skills to help them be successful to obtain and keep a family sustaining job. And that I could say a million other things, but we don't have time. But just to keep the large perspective kind of what our Utah goal is, not, and that is, I think, different than whatever someone,
it's in our document.
Yeah,
it's in our USBE document. But I agree. I think the CTE programs are wonderful hands-on learning for our kids, where they develop really important skills that can carry over into their future to help make them be able to provide for their families and their futures. And I think it's great that we have those options. I'm certainly not dissing on those classes. I think having more opportunities open is fabulous, as long as we are not socially engineering it and pushing even maybe kind of steering these kids in a certain direction, or saying that they're not college and career ready until they have the right attitudes, values, beliefs, which is different than skills for collaborating and communicating.
Yeah, it depends on, I guess, where you are is where you sit. So I guess there's different room for differences of opinion. Talia, do you have any last thoughts about that? And I see now further hands. If someone likes to make a motion, we're ready for that. Talia, did you have anything to conclude with, or did we get this to death?
No, I think you guys covered it. I would just say we are very cognizant of those same concerns. And as we talk about CTE and how we move it forward, as we work with industry partners, we're very cognizant of those concerns, and we share those same concerns.
Thank you. Thanks for that final summary. Member Davis.
I had that question on the funding.
Yes.
What's the average difference between across our LEAs between the restricted and unrestricted rates, indirect cost rates right now?
Wendy, can you answer that?
So I would need to pull that and calculate an average. I can't tell you the average, but there is, so those for each on our USB website in financial operations, the annual rate that each LEA has negotiated is posted publicly. And so I could get that to you, but I would have to go pull it real quick.
Have just off the top of your mind, like, are most of them like around a 10% difference? I mean, how much money are we talking about when we say you have to charge the lower rate?
So it depends. So it really depends on the LEA. Some it is as much as 10%. And in others, some have decided not to negotiate an indirect cost rate. So some of them decided at 0. But it really depends on the LEA. There's a pretty big difference between from LEA to LEA, but the unrestricted rate is.
Oh, we lost her, but I think Chair Lear.
Yes.
It's Talia had maybe that answer.
Go ahead.
If I may, I just pulled up the chart for this current fiscal year, and it's on average at least 10%. And there are a large number, I'm surprised I haven't looked at this chart recently, but there are a large number of LEAs who don't negotiate an indirect cost rate, either restricted or unrestricted. But I would say 10% is just a very, very rough average difference.
Does that help, Cindy?
Yeah, so for the LEAs who don't have zero, and I would be interesting to know how many of those were at zero, but I know we've got time constraints. The others we're looking at about a 10% difference. If we say you have to charge the lower rate, and they're saying, but CTE courses are more expensive, so we think we should charge the higher rate. I'm okay to move this forward today, but I think that these issues, these three issues in particular, will probably come up again in the full board meeting.
I'm sure they will.
So I just want everyone to kind of be aware of that there might be a hearty discussion or potential amendments that are brought forward in the full board. I just got this email this morning, so I haven't had time to really dig down in and look at all the charts and things, but you know, I'm okay to move forward today with the understanding there may be additional conversation in full board.
And I had one more MOE question to Leah that's pretty simple, and either you or Wendy, who seems to be, maybe Wendy's frozen, but if you can't answer that, as far as I'm concerned, it can wait till the board meeting. But my question about MOE, and this is, she gave me a much more technical explanation than I really needed. Because what I wanted to know is MOE, and she explained that the federal and state requirements are intertwined, but maintenance of effort at the federal level is required. And she explained, I thought, that the state has imposed some similar kind of intertwined maintenance of effort amount. But if the state wanted to, or if a LEA were to say, we're not going to take Perkins funds anymore, then that MOE at state imposed would still be there. Is that correct?
That is correct, because there is the intent of add-on funds is to supplement regular WPU. And so for every student in a seat in a CTE classroom, they are earning regular WPU, which is meant to be spent across the board for all classes. Add-on is to supplement regular WPU for CTE programs because they are higher cost in many, many different ways.
So the intent of the state MOE is to address the same concern as the intent of the federal MOE, whether or not they take federal funds, which is a helpful to me explanation of the reason that the state imposes MOE requirements that are similar to the feds.
And can I just really quick, Chair, also reaffirm in my mind that stayed status quo. We didn't make any changes to the MOE from status quo.
Right, which is a
Okay.
state.
Because I think there's a perception in this email, at least, that there were changes made to that MOE requirement.
Okay, so having resolved those last two questions, would a board member or committee member like to make that motion? And I see no hands.
I can do it.
Go ahead, Cindy.
I move that the committee approves R277-911 draft 3 on first reading and forward to the board for approval on second and final reading.
The motion is that the committee approves R277-911 draft 2 on first reading and forward to the board for approval on second and final reading. Do you have any final discussion to this? Thank you to staff. Matt?
Yeah, just I appreciate what has been said here. I know this has been an ongoing discussion. I want to thank Cindy for taking on this email, these questions that we've all had. And knowing that we are taking this to the full board, I hope that those watching and those in the public understand that this is important to us and we want more eyes on this. This is why we're moving this forward. And so I guess I'm speaking in support of the motion with the understanding that this is important to us. We want to make sure we get this right for LEAs throughout the state. Thank you.
Thanks, Matt. I appreciate that clarification.
May I clarify, draft 2 or draft 3?
Draft 2 is what I have. Is that accurate, Angie? Angie's saying no, it's draft 3.
Correct. It's draft 3.
Draft 3. So I'm going to repeat that motion then. Right? The committee approves R277911 draft 3 on first reading and forward to the board for approval on second and final reading. That's the motion. With the committee members, please vote. And I see a vote of 3-1 with member Klein voting in the negative. Thank you. Thank you for that very healthy discussion. Thank you for coming with the answers. It's helpful to have Wendy here to help with the financial side of it. So again, I appreciate the staff's preparation. We have one more item on our agenda, and it would be item 1.5, R277217, Educator Standards and Local Education Agency Reporting. An amendment is proposed. Mr. Rasmussen.
Thank you, Chair. Ben Rasmussen, Director of Law and Professional Practices. Good to be with you this morning. We had a request for staff to consider whether it would be appropriate to include a reference to the new sensitive materials laws in the educator standards. And so we have a proposal to add that to R277217. The only changes on lines 62 and 63. We already really have a provision that kind of addresses this. In that we've already got the provision that they shouldn't expose students to inappropriate materials, but we've added that reference there to include sensitive materials as described in the statute recently adopted. So that is what is proposed, and be happy to answer any questions you may have. Chair, you're muted.
Sorry, I turned off my just so you wouldn't have to hear my cuckoo clock. I think we had a number of, which is a little Freudian maybe. We had a number of amendments proposed by member Klein to this rule generally. And I guess the best thing to do is, and when I say I guess, let me propose that we take those amendments individually, and maybe we could start just for the committee's kind of recollection and collective recollection of everyone listening. Ben, maybe you could speak to how the changes and the more comprehensive approach to these requirements came about a few years ago. I don't know if you've seen those amendments and understand the rationale, but could you speak to that, the way that these changes, the way that the rule changed from something similar to what member Klein is proposing to where it is today and how it changed? And maybe Andy had her hands up.
Before board member Lear, before Ben, he's going to be the best person to speak this. I just wanted to apologize. I did not see board member Klein's email that she sent this morning and so I apologize. I just seeing that right now for the first time, and Ben has not seen it because he was not on the email. So I just forwarded the email to Ben. And so I just wanted to apologize to the committee. I did not see board member Klein's, but we'll take a look right now. And I think he can answer your question and we'll start looking at those amendments ASAP.
That'd be great. I think that I've given you sort of a strong clue about what these amendments look like. So with that, Ben, you want to go ahead and speak to why this rule changed a few years ago?
Yeah, thank you, Chair. A few years back, we did do a comprehensive task force that involved board members, involved representatives from a number of stakeholders. and we took the old educator standards rule, which was 5/5, scrapped that and drafted this new rule. There was extensive feedback and a long process involved in that, and we got at this new rule, which I think everyone involved felt was a good step forward through that process.
Thanks, that's helpful. Let me just add, because I was part of that task force, that this was a very healthy and I thought comprehensive group of stakeholders that included teachers, and included community representatives, it included people who had served on hearing panels and as hearing officers in the UPAC process, and including a number of staff people, staff attorneys. And so it was a very well-informed and discussion that lasted over a period of about 12 weeks, and then reconvened a year later to again assess our progress, or to see if there was progress. So I feel like there was a really legitimate and comprehensive effort to move in this more general direction. And let me just ask one more question, and then I'll go to Member Klein. But do you feel like, as a person who works more than most other staff members with teacher conduct and misconduct, do you feel like the changes to this rule have served us well? Jen? Sorry.
I thought was that a question for me?
On the spot. I just said, given that you're the person who works most in the office with the issues of educator misconduct and conduct, do you feel like the changes to this rule have served us well in the last 3 or 4 years?
I do think the way that we reformatted the rule has been a lot more clear. It's helped LEAs as far as understanding what needs to be reported, and I think that it's a lot clearer than what we had before. So I think it was a good step forward.
Thank you. Okay, Member Klein. You're muted, Natalie.
So you want to take each of these individually?
Yes, I don't see any hand to adopt these, to make this a wholesale adoption of your amendments. So okay. I will, by, what should I say, inference, understand that we'll look at these individually.
Okay, sorry that I wasn't able to just add them right into, I didn't have time to write them into the rule so you can see, or probably I didn't give staff enough time to do that for me to make it a little easier, but I've tried to just organize it under educator may not and educator shall, those 2 main sections. So hopefully that is clear enough as far as giving context. And if we feel like they belong on a different, like some of them, I mentioned what line I wanted them added in where I thought it might fit best. Others, I just wanted to add it to that section wherever it makes sense. So the first one.
Mention one more thing. I'm sorry to interrupt again. Sure. Member Klein, let me mention one thing. I think if you will propose your amendment, Ben can, I hope, be facile enough to show us where this would go. And then also, if he has a comment about Angie or Ben is the person who works more directly with this. If he has a comment about this, I'll just ask him as a matter of routine to speak to that. If you don't have a comment, then we'll entertain any member comments that you have to these.
Okay. So my first motion would be to add on line 21, a continuation of an educator may not be forced, coerced, threatened, or compelled to teach or affirm that which violates his or her conscience.
Ben, do you have any? And I know you're doing this cold, so I very much appreciate it. If you don't have a comment, that's fine. We'll just vote on this. But do you have any?
I don't have anything to say about that, no.
Any?
Although I would actually, looking at the way that's written, that's not really a standard for the educator, that's more something for those that are above the educators. This is the standards for the educators. Does that, I don't know if that makes sense, but this doesn't seem like it's something
Okay.
we'd be telling the educators not to do.
So this maybe, I think you're right, is maybe better in the educators shall, and I would preface it with be protected from being forced, coerced, threatened, and to go against his conscience. I don't know if that would work better.
And
If-
go ahead, Ben.
if I may, again, that's not something, these are things that we're requiring the educators to do. It sounds like what this is trying to do is to provide a protection for educators, which is a laudable goal. But I don't know.
Where would that go and how? I mean, this is
educator's
the only
standard.
one I have that is like this one. This is unique to my others are very specific to educator, may not, but I wanted to put a protection in there for teachers from having to, be compelled to do that, teach or affirm that which violates their conscience. So I don't know if that goes in a different rule or where that would go, but I'm open to suggestions.
Ben?
I'm just trying to remember if we have administrator standards rule. I think
We don't. I don't think we.
that's really where
I might
this
suggest.
would be aimed at. It seems to me this would be right subject matter for a separate rule.
Right. It seems like
Or need to go along in a separate.
it might even fit better in something like 328 or something generally that is a directive to an LEA. That would be my suggestion. Matt, you have a comment?
Yeah, I just on this, I'm worried about this, not because I want educators to be forced, coerced, or threatened or compelled, but there are certain schools with certain models, if particularly charter schools that have certain models, and sometimes an educator will say, yeah, I'm willing to do that. I'm willing to teach that ideology. And then when they get in there, over time, life happens. They might have a change of mind or change of opinion. And it should be within the LEA's right to say, this is what we do here. And if you don't agree, then you have to leave, right? And so I think that adding this First Amendment might take that away from our LEAs to say, no, this is the model we use, again, specifically in charter schools. And it might be the same in a traditional public school, where there are certain expectations. Do you see what I'm saying here? We're
Right.
we're in a gray area, and I'd rather not put our LEAs in this position to say, okay, you can say whatever you want. I can't force you or threaten you, or you know what I mean? That's my concern with this amendment here. With this,
Yeah, it's not. It's not speaking to. They can say whatever they want, but just not. But I understand what you're saying. So maybe we can set this one aside and have them come up with something that's fleshed out that protects both the school as well as the educator in a situation like that.
But maybe it sounds like look for a different place for it.
Yes, we can. Yeah, we'll figure out something at a future time on that one.
Okay, without objection, we'll move on to your next.
Okay. Okay, so my next motion would be to add to line 30, promote, educator may not promote sex, sexual lifestyle, sexual identity, sexual expression, sexual activity, sexual exploration, sexual experimentation, or fetishes.
And can we look at where that might be added, Ben? Come down when she said line 30, so can you go down a little bit farther? Yeah. Shall not.
Just before line 30, between 29 and 30.
So it would,
insert it there.
So that starts out with, let's see how it starts out.
It just is, they all start the same. An educator may not.
Not. Any comment, Ben, about that? And I'm sorry, I'm not trying to pick on you, but.
point of clarification.
Did you have something to say first?
Yeah, I'm just asking, Natalie, you're just hoping this will be like number 6 or number 5?
Yeah.
Just added somewhere.
Just add a number.
Okay, thank you.
All right. Ben?
I think that to a large extent, this is covered by our line 99, which says that an educator shall comply with federal, state, and local laws. I think there are already a number of laws that talk about what the educator can do with regards to discussion of sex and sexual type issues. The Student Data Privacy Act is the first thing that comes to mind there, which says they have to have specific permission to even talk to students about those types of issues. But if the board is of the feeling that that needs to be spelled out more specifically, I don't know that I have any specific issue with that, other than I think it's already covered.
Well, it is an issue in our schools, more and more in this area. I think it needs to be spelled out
Matt?
because it's currently not clear enough.
And my feeling, I'll just speak quickly to say that this is the direction we moved away from with that comprehensive task force 3 or 4 years ago, so that there would be an ability and an opportunity for the Professional Practices Commission to look at these in a more holistic way, not in as limiting in some ways or pointed way. Member Hymas.
Yeah, thank you. I've had the opportunity to look over these proposed amendments that we're going through, and I believe that most, if not all of them, I won't say all, most of them are protected under law, but to Natalie's point, how do we, I guess we have a different issue here, because I see the same thing Natalie sees in many of our classrooms. I wouldn't even say majority, but I would say many of our classrooms, some of these things are happening. And I don't know if our principals don't feel empowered, or if they don't have the resources to say, okay, I can get rid of this this class or this teacher or this program, but that really hurts the school. I guess my question or my thought to this is what can be done when something like this happens. I mean, we take it to UPAC, but usually it'd be like a whole process, and it might not even be worth it to the, I don't know. I feel what Natalie's saying. I feel like sometimes our parents feel stuck, like they're breaking rules, they're breaking laws, but nothing can be done about it. And so by putting this in there, it's made out more clearly. There's no question about that, but it's to your point, Ben, it's already covered. And so I feel like just by adding these, we're going to be in the same boat anyway. I don't know if any issues that Natalie's hoping to avoid here are going to be avoided. So anyway, those are just some of my thoughts on these amendments, because I agree with many of them. But again, I'm hearing what Ben is saying is that a lot of these are covered already.
Ben?
Yeah, I wanted to point out, we got a text from Ashley, the Assistant Attorney General. She said she was concerned about using the language of promote on line 30 there. The example she gave was—
Use the language of what? You cut out.
She said that using the word promote might be problematic. She gave the example of a trans teacher telling a student their gender identity. She indicated this might be violating of federal Title IX laws. I just thought we ought to share that she thought that was legally problematic.
And this is why we have a problem.
Could you turn off your video and say what you just said again? Because you were cutting out and I couldn't hear.
Thanks.
I'm sorry, I'll try that again. Maybe Ashley didn't want to jump in herself, but she texted Angie and I and said that she thought this was problematic, that the word promote is kind of ambiguous as to what that means. A teacher, gay or lesbian teacher, might indicate that they have a partner, or a teacher might indicate what their identity is, and that could be problematic. It could violate Title IX if we're prohibiting those teachers from sharing that kind of information. And Ashley could add to that if she doesn't think I've covered that well enough.
And another example of that might be a teacher maybe just talking about his married life and be seen as promoting heterosexuality, but still something that's perhaps not appropriate. I have a suggestion after we finish discussing this that might be, that might facilitate doing this a little more effectively and not in such a hit or miss manner. But Ashley, you didn't have your hand up, but do you have anything to add to your concerns about line 30?
No, I think Ben addressed it. I think the word promote, it definitely gets dicey with, how that would be enforced or reported. Like Ben said, if you have a trans teacher who is just, expressing their gender identity, is that going to be called out as being a promotion? I think that there are some things there that are that could get a little bit legally questionable.
Thank you. Ben, did you have something else? Your hand's still up. Nope. Natalie, would you like us to vote on this, or do you want to hear my suggestion? You want to vote on this?
Yeah.
Following.
Vote on them all.
All right. If a vote on this, I was going to propose, and maybe this is not something you want to do, but I would propose that rather than read through these cold, with our experts not having seen these in advance in order to bring their research, their best background to us, then I was wondering if maybe this could be something, maybe there's a need for a task force to re-examine the way the rule was changed and go in a more specific direction rather than just cherry pick certain issues. Is that something that you would support, Natalie?
I would prefer to move ahead and keep
going
through
every time, no matter what. Is that what you're saying? Okay. Then we have the proposed amendment on line 30 that would add promote sex, sexual lifestyles, sexual identity, sexual expression, sexual activity, sexual exploration, sexual experimentation, or fetishes. Any other committee comments? I see no hands raised.
I do.
Member Davis.
How many of these are we looking at total? Is it just these 3?
There's like 10 or 11, right, Natalie? Or 12 or 15.
I mean, if we're going to have this many extensive amendments in a rule, it would be great to have like a notice a day or two ahead. I mean, I feel like this is really fast. I mean, I'm concerned about line 21 for the exact same reasons that Member Hymas suggested. While I personally believe that promotion in line 30 means that you're trying to tell a student that they should be a certain sexual lifestyle or sexual identity or sexual, and I don't think teachers should do that. But is that what promote means to everyone? And now I'm hearing that legally it might mean something different from our AAGs. So and if there's going to be like 10 of these, then I think we need some time to do this well, not just hit or miss. Go, I think promote means this to me. It means something different to board member Klein. It means something different to the attorneys. I mean, what does it mean? And do we need to define what promote means if we're going to put this into our, I personally think all that stuff should be kept in the car. When we go to school, we just teach what we need to teach at school, but what are we saying here? If a teacher goes by, Miss Smith instead of Ms. Smith, do they get fired for breaking the code? Is that what promote means, board member Klein? I mean, is that what you're saying? If a teacher goes by Miss Smith instead of Ms. Smith, would that teacher be fired for breaking the code? Is that what you're saying here with this amendment? Can I ask that, Chair?
Sure. I would kind of add another example. If a teacher goes by Ms. Smith Hogan and Hogan is a woman, is that promoting something inappropriate or promoting anything? Do you want to respond to that, Natalie? And then I think Deputy Superintendent Stallings has her hand up. Go ahead, Natalie.
If I just be straight, I feel like this is a way that teachers are getting around the law and making students feel uncomfortable. It creates a distracting learning environment. They feel compelled in their speech, as far as how they address somebody, may cause them to go against their conscience, to call somebody something they don't believe they are. So there's a lot of issues here that, you know, those that are activists for this lifestyle or agenda or whatever you want to call it, have very cleverly found a way to get around and force this on.
Follow-up, Chair.
I'm not clear what you mean by this lifestyle or agenda. What is this lifestyle or agenda?
A sexual lifestyle or a sexual identity lifestyle, a way to identify so that they somehow can get away with things they wouldn't necessarily be able to otherwise, because it's their identity and we're not allowed to question that. And that's an orthodoxy of compulsion that creates a hostile learning environment for many.
Member Davis.
Yeah, just a quick follow-up. So in the two scenarios that were mentioned, if a teacher goes by Miss Smith instead of Ms. Smith, or if a teacher goes by Ms. Johnson Harris, and Harris is a female partner, if the students call the teacher Ms. Johnson Harris, or if the students call the teacher Miss Smith, that would be a violation of this amendment that you're proposing, that equates to promoting, and so therefore a teacher would be fired for these violations. A teacher would be fired for those two scenarios. Is that your understanding with the amendment?
I believe
I just need a yes or no, because that tells me how you define promote
in this amendment.
If they are pushing this identity or on their students and expecting students to go along with, regardless of their conscience or their own personal beliefs, then yes, it's a promotion.
Okay, so, okay, that helps me know what you mean by promote, because that definition of promote seems different than what I think a dictionary definition of promote is. That requires more action. So I have to really
it is one way of promoting.
Okay, I see
it could be seen as one way.
I see your hand, madam. We go to Deputy Stallings first. Go ahead, Deputy.
Thank you. I just wanted to give a bit of historical context about this rule specifically in the work that's been done on it, not to say we don't stop the conversation, but this rule is, like 419 in the finance world, I would say this 217 as far as educator licensing and discipline is a very highly looked at and relied on rule for the system. And because of that, when we've had changes related to it, it's often taken a lot of discussion, and not just committee discussion, but opportunities to review data from that our UPAC team has collected related to incidents. We've often in the past included principals from the field, members of UPAC, those who serve on the commission, at times even attorneys. The last time we reviewed this rule, we had a former judge who was the facilitator and of the discussions, and it was, many, many meetings and hours of discussion. And I also wanted to let the board members know who weren't here back in, I want to say it was 2015, that the State Board of Education was sued related to amendments made to our UPAC rules, and because we did not include stakeholders. And so I just wanted to share the historical background that if we make changes to 217 will likely have either requests for public hearing or other requests from stakeholders to be able to weigh in. And board members may want to receive data from our UPAC staff on incidents. A lot of these things might be something that Ben, for example, could show where existing provisions of 217 cover that, and maybe even provide some information on the number of complaints that UPAC receives on those. Just wanting to give some context on additional background information that you all might find to be helpful as you discuss this. Either obviously we won't have the opportunity to have that for you today because this came, this morning, these amendments. But if the committee does want to discuss these in a more robust manner and to get some data on incident reports or information, I'm sure Ben would be happy to kind of talk about either a crosswalk of where some of these amended may nots or shalls might be covered under existing provisions, or how they could be amended. Just offering that, and wanted to give you that historical. This has often been a rule that even before my time on the board, there have been either large task forces or interest from the system in general. That's it.
Thank you. I'm going to go to Ashley Beal, and then I'll go to Mr. Hymas. Go ahead, Ashley. AEG.
Thank you. Yeah, I just wanted to briefly just iterate here that if the intent is, as Vice Chair Davis said, that with that example of using mix as, instead of miss, and that would be banned, then that's certainly going to run afoul of Title IX. Office of Civil Rights says, manner free of discrimination based on sex, including sexual orientation and gender identity in employment. So that's certainly going to cause legal issues.
Thank you, Ashley. Mr. Hymas.
Thank you. I think it would be illegal to do that, right? Discrimination based on those things. But I do wonder, I appreciate Cindy asking, what does promote mean, right? That makes a big difference. And I wondered, and I'm asking this to staff as well as members of the committee, if it would be appropriate to amend this by saying discuss with students sexual lifestyles, sex identity, those types of things. That those kind of discussions in a classroom setting are inappropriate in my opinion. I think I would remove sex, just because sex needs to be discussed with students in specific classes. So that one is already listed somewhere in the rule, right? Or in a rule or in the law that says you have to be a health teacher or certified to discuss that. But me personally, I don't feel it's appropriate for teachers of any sexual identity or preference or gender identity preference to have conversations about sexual lifestyles, sexual identity, expression, activity, exploration, experimentation, or fetishes. That I do agree with. So just thoughts for, I guess, first it would go to Natalie if that's a friendly amendment, and then it would, if it isn't, then we vote and whatever the process goes on. But that's my thoughts.
Member Klein, that was a question to you. And can you just give a response to that question, and please keep it short.
I think discuss is also a good thing. I would be okay with promote and discuss.
Promote and discuss, though, so you won't switch to discuss.
Well, there's a lot of promotion going on that happens without any actual discussion happening. And that also needs to be addressed, because while it's important that we protect individuals from discrimination, it goes both ways. We have students that are being discriminated against, and their if they're a person of faith or they just have a sincerely held belief that there are two genders, they are being discriminated against. And in order to protect the other side, those that believe otherwise, if that makes sense. And so it has to protect both ways.
Well, and it doesn't exactly make sense to me, but let's, I really need our responses and comments to stay narrow if we're going to go through all of these today. Mr. Rasmussen and then Cindy.
Yeah, I think the use of the term discuss is problematic, especially if you're just saying discuss with students' sex, because I think there are quite viable reasons why they would discuss sex with students for health class or in sex education. So I think that's a little too sweeping with regards to that. And again, I think discussing the other things, we have a state law that discusses the mechanics of when they can do that with parental consent.
I think Matt asked that be removed, sex, and for that reason that you just described.
The sexual expression, right? He did ask to.
All the rest he would say, just taking out sex is what he recommended. Is that right, Matt?
Yes.
Okay, thank you. Cindy.
So 2 questions. I don't know if discuss changes it from promote. Promote to me seems like an active selling of, like, you should do this, you should do that. But if you do leave promote in or discuss either one with the understanding of the motion maker, it seems like we're being asked to pass a rule that's against the law. So that's really difficult. The other question is, Director Rasmussen, you mentioned that in our state code currently, is there a law that has to do with the other things outside of sex? I think Matt suggested taking out sex, and I think that was friendly to Natalie, but I can't remember. Is there a law that talks about these other things? I mean, it is kind of inherent in the language that's already there, but are they specific in anywhere?
Mr. Rasmussen?
Yeah, so if you, in the Student Data Privacy Act, there is a statute that talks about a number of things that teachers have to have parental consent to discuss with students on sexual lifestyles and sexual attitudes. If I remember a little slow, but that is in the Student Data Privacy Act.
Thank you. And I want to make sure on this one we have the amendment correct. Promote or discuss with students. Thank you. I think now it is.
I would like.
Just a minute, Natalie.
Okay.
And I'll come back to you. Cindy, did you have other comments to that?
So am I hearing that this is already in the law, and is that referenced somewhere in the Educator Code of Conduct?
They have to, it's registered, it's in the Code of Conduct in that it says educators shall follow the law. And that means all laws, including the one that Ben just mentioned.
That is correct.
If we could see, someone could screenshot the language of the law, that would be helpful. I know that's asking a lot right on the spot.
It's 539203. It says that parental consent is required to discuss sexual behavior, orientation, or attitudes.
Is it 53G or is it 53? Okay.
I mean, I'd feel more comfortable just quoting that here.
Is that okay with you, Natalie? Would you accept that as an amendment to this amendment?
Can you read it again?
Let's go to the section and we can see it. Right
there. That one, subsection 1.
Is that paragraph at the top?
That's the shall not part of it. Shall include prohibitions on of any but then or any whether information.
Oh, I see.
Or any family members. Sexual behavior.
Subsection 3 carries that on to say you can't even discuss those in the curriculum or other activities without parental consent.
I mean, if this is rule is being used often, sorry, our garbage collector's here, then we should probably quote A through H, because I mean, if we're gonna put one in, we should put all of them in.
And number 3.
And
So that it covers more, so it's clear it's more than just surveys.
Board Member Lear.
yes, ma'am.
I just wanted to point out that right now, I mean, essentially all of 53E, F, and G, educators are required to comply with.
Law.
It says comply with all federal, state, and local laws. So existing would be the requirement if a parent or other person or teacher were to feel that this section of code were violated, or an administrator were to feel that their teacher was violating this section of code, they could report that to UPAC as a violation of that section.
Angie,
Yes.
can I interrupt you? I'm sorry. There is a specific provision in the standards, line 90, that says they can't violate the Student Privacy and Data Protection Act, which this would include.
All right, so that, Natalie, are you willing to say that this is already in the law?
I think it needs to be spelled out
And
so that parents have something we can point them to that helps them know in plain language without just by reference.
so despite the fact that we have line 90, despite the fact that we have the line that says shall follow state and federal laws, you want this stated again as proposed in your amendment. Okay, then, and Matt's proposed some amending language, which you're okay with. So Cindy, unless you have something interesting, and sorry, that was a mistake, misspoke. Unless you have something to add, and Matt, do you have something to add, or let's just go ahead and vote on this?
Well, I need to clarify my addition. I am thinking about this, and again, if I go back to promote or even the word model, I feel like it wouldn't matter. Nobody would be able to live up to this, right? And this I'm hoping to express my concern. If I were to go in as Mr. Hymas, then I am promoting my own sex and or gender, right?
It's different than sexual, though.
Well, but if I went in as Mrs. Hymas, you're saying because I look like a man. Do you see what I'm saying? Like if I went in as Mr. or Mrs., it shouldn't matter. That's the preference, but you're saying that that's a promotion. And I have personally worked with individuals who have had the appearance of a gender and preferred to be called another, be it Mr. or Miss. And legally, right, I can't discriminate and say, well, because you look like this and you're calling yourself this, I can't turn you away because you're promoting something. That's where my big hang up is
Okay.
here. And so again, for line 30,
So
with
discuss.
students, just start with discuss with students. I can
That's fine.
jump on that.
Let's do that then.
Okay, and here's my problem with that, Matt, for entering into an informal discussion. If a student makes a sexual expression and you correct the student as the teacher and say, you're not, Joey, you can't say that in class, then you're discussing sexual activity or expression with the student. And we, of course, want teachers to be able to correct students and stop inappropriate comments. So I think discuss with is probably at least as problematic as promote, if not more so.
I see that. I can see that. I've had to have these discussions. You're right.
As we have, if we've been in high school classrooms. So I think saying discuss with would keep us from doing exactly what our concerns might be. I'm going to go to Chair's prerogative and go to Deputy Superintendent Stallings and see if she can help us through these words that are more loaded than we are thinking they are.
One recommendation is if you look at the section of code that we were looking at earlier, it does allow for some of these topics to be discussed with parental consent. And something that was brought to my attention or a reminder is that some of our LEAs have clubs like an LGBTQ plus or Gay Straight Alliance, where students are participating in discussions that might not touch all of these, but some of them, and they are with parental consent, meaning parents have to approve or consent to the students participating in that club. So one thing I was going to maybe recommend is that we, at the very least for this one, make a qualification like the code does that allows for some of these things to be discussed with parental consent, because discussion in and of itself actually might be harder than the promotion. And I know we've already talked about the complexities of promotion, but at least with promotion, it shows an intent of like something, whereas this discussion could get very difficult because, as board member Lear stated, what if something spontaneously came up? We do have exceptions for that, for example, in our curriculum on human sexuality, for example. So we may want to add, all I'm trying to say is we might want to add references to some exceptions related to parental consent, or if they come up either spontaneously or as part of a discussion about human sexuality, which again requires parental consent. That's it. I just wanted to, you may want to add something about allowing it if parents consent.
Thank you. So we could add something. Is that something you'd support as a friendly amendment?
That's fine. That's fine. How would you like that worded?
Can I remove my amendment then? I hear what Angie's saying. So if we go back to the original verbiage that Natalie had, and then work from there, would that be acceptable, Chair?
It's fine with me. I think.
Well, it sounds like we could. I mean, if we're going to put a qualifier on it, then you could put promote and discuss.
No, I think
with as long as you include the qualifier.
I don't care if parents give consent or not. If a student makes an inappropriate remark, I'm going to correct him in class as the teacher, and I don't care if parents give permission. That's going to happen.
Okay.
So I don't think that. I think we've still got a problem because discuss is so broad. And
so you think promote is better with the including the qualifier?
I think promote has a different set of concerns because you're thinking of promotion in one way, and at least Member Davis and myself are thinking of it more the way the dictionary defines it, as more of a pushing something or a furthering something that is an objective evaluation, not just I'm sure there's an agenda there. So I think promote has a different set of problems. So I could not support either of these with the language that's here. I think if we want to go in a more specialized direction, an individualized direction with these, I think it bears more discussion and more legal analysis. So I couldn't support this right now without that extended legal analysis. Cindy, do you have something to add?
Yeah, I have a substitute motion to just in the section list the prohibited acts that are in the law with a reference to the law. And I know we don't like, regurgitating law in our board rule, but it's the safest way to do this that accomplishes the goal of not truly promoting. But it also a lot of time and vetting went into the language of the law, and it is the law. And if we need to remind people of the law, then we can put the language here. But I don't want to create new language with the motion makers' verbalized understanding that if you have a name that is the name of a partner's last name, that is a violation of this, then it's put us in a box that legally we can't vote for this. It's really tricky. So I think we just, my substitute motion is instead to quote the law, the actual law.
And I think that's probably better than what is here. I still wouldn't support that because I don't believe that we should repeat the law if we get a few words wrong. That confuses people. So I think that causes a different kind of confusion. I still couldn't support that, but that's your substitute motion. And it's in order, so we'll
At
accept
least
that.
it's legal. We know it's legal. There's not a question of if it's legal or not.
Yeah.
And it reminds and reiterates that teachers can't do these things.
Which is, there's a lot of that could be included in this rule, reminding and reiteration.
I get it.
So that's the substitute motion. Let's take one vote on this. Let me remind the committee that we've got till 12 o'clock. There's nothing pressing about this rule at all. And if we keep discussing these amendments, we may not be able to pass what was the sort of prime directive of having this on the agenda. So let's go to this amended motion and vote on this.
I'd like to make a comment regarding
I'm sorry, I thought you were waiting to.
the substitute motion. Yeah, I just, I'm not opposed to including this in here. I think it's good to reference that. But I'd also like to keep the other language as well. Can we do both?
So no, you'd have to vote against Member Davis's substitute motion, and then we'd go back to your motion.
Can we just clarify the first motion with a reference to that law?
Well, that doesn't accomplish what Member Davis said, who wanted to reiterate and remind.
All right.
Is that?
You know, I don't think anybody thinks those things listed in the motion should be promoted, meaning actively encouraged by teachers in a classroom ever. But legally, as has been publicly stated, that if a name could infer something, then that's the motion maker saying that's the definition here. And legally, we don't have the luxury of voting for that legally. So this is the best I think we can do, because it is included already in the law. At least we have the very clear knowledge that this one is legal.
So we are faced with the substitute motion or two motions.
Just make sure we're listing those things that are in this section. We're listing those things that are prohibited.
So you're intending to list that,
not just right, including section, blah, 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 but we're actually listing the things that are prohibited.
And all right, can you copy and paste that full list? Although it's a little convoluted for purposes of this rule, because there are other the way that it's explained is more related to psychological surveys or treatments, and then only in Friend 3 is there the prohibition on the curriculum activities or school activities. So it's we can just lift that list, but it doesn't really do it justice, because
I see what you're saying.
It's more thoroughly in what's before and after.
This is why we need more time to think through this kind of stuff, but I do see what you're saying.
Would you like to make a motion to that effect, Member Davis, and maybe see if we could get 3 votes to support spending more time on considering better language? And maybe it would be undoing what the task force 3 or 4 years ago did, but if that's the will of the board, then that's what we should do. But it seems like we should not be, it's a waste of time to be looking at this language without without more legal guidance at every step. So Member Davis, or Member Hymas, do you want to step in with some great insight?
I agree. I agree with you, Chair Lear. I would like to spend more time on this to make sure that we get it right. There are we've covered two proposed amendments here, and we're not going to have time, and this is not something that should be rushed, because it is important. There are many of these amendments that I think are, in my opinion, I know I'm only one man, but in my opinion, would do well to be part of this rule, with a little bit of discussion and maybe tweaking. So I would support. I don't know if it's another meeting. I hate to do that because our time is valuable, but it is important. So I'd support either another meeting or, I mean, if we push it back to October, we're going to be more things are going to be added to our agenda. So I don't know how that looks. It would be helpful if our staff and AAGs could look at these and see where they would fill in and say, okay, this is covered already here, or this one could be put in here. That would be, all those things would be helpful to me.
Thank you. I was hoping maybe that we could have a motion, and I'm happy to make the motion to, as Angie pointed out so well previously, that we could not only look at this in a committee meeting, but maybe look at it in a more inclusive task force. Forgive the word, that involved more stakeholders, and we could have that discussion, because this is one of those rules that has legal issues. It also has really substantial training issues for the field. Angie, do you want to help us with this dilemma?
Well, I just wanted to add, and I don't mean to complicate it, but when we amend 217, we are going to need to amend 215 and likely 210 as well. So 210 has the definition section, and 215 is the presumptions section. So for each of these things we add, we'll need to make sure that we're then addressing what the presumptions would be in 215. So just wanted to throw in that we'll probably want to discuss all three rules at the same time. And
more comprehensive.
Yeah, just wanted to share that it's more than just this one rule.
Thank you very much. Member Davis.
I just want to say that my husband just walked in and made funny faces at me, and I said, "You are a nut." And I want to make certain that everybody on this meeting knows I'm not referring to any of you. I was talking to him, and then I looked over, I'm like, "Oh, great, my microphone is on." So anyway.
No offense taken.
I support, taking some time to, can I get the email with all the amendments? I never got the email with all the amendments on it.
That makes it even harder. So I'm going to take it upon myself, as chair's prerogative, to make the motion that the committee refers this list of amendments, as well as any others that committee members might have, and refer that discussion to board leadership for discussion about how this could best be handled. Whether it's a reconvening of the task force that took place several years ago, whether it's another committee meeting, whether it's a new group that includes appropriate legal counsel. But I think this is a bigger issue, as Angie points out, than just this rule and this committee. So my motion would be that we refer this, rather than take a motion on this rule now, or this proposed amendment, which was very simple, and that we refer the discussion of this rule and all related appropriate rules to board leadership to place in an appropriate location or discussion in the future. Does everyone understand my motion?
Well, if it needs to go to board leadership, I mean, it can just come back to this committee, but it just all the information that Member Hymas asked for would be very helpful. And then our committee could make a decision if we want to ask board leadership to consider sending it to the task force. But we should probably do some due diligence ourselves. I'm just speaking to the motion.
And I hear what you're saying, Member Davis, but I feel like this committee needs to have those other rules in front of it too. If you heard what Deputy Stallings was saying, that this is not a single rule discussion or analysis, which is why I would put it more to board leadership to draw those conclusions and decide where it belongs.
That makes sense.
So again, let me say what my motion, my motion is that the committee refers and defers the discussion of R272 board leadership to determine whether 217 should be discussed by a task force or there should be continued discussion of the rule as part of a future committee meeting or take other action. So that's my motion. Do I now need to repeat it? It's now on the board so you can read it. Okay. Further discussion to that motion? See no hands. Would committee members please vote? I see a vote of 3-1 with Member Klein voting in the negative. So I think our work today is done. I have no other items on the agenda. Any further comments by board members? Thank you for your attendance. Thank you again, staff. This has been a really content-heavy discussion on only a few items. So I really appreciate your expertise, your participation, your willingness to help us and answer questions on the fly. That's a really great skill. So thanks again, and we will see you next month.
All right. Thanks, everybody.
Thank you. Bye-bye.
Thank you.